The next requested lesser is the third-degree felony murder. Felony murder, third degree, the state has to prove three elements. One, that the victim in this case is dead. Two, it occurred as a consequence of and while the defendant was engaged in the commission of what's called a non-enumerated felony. And then three, that the defendant was actually the person who killed the victim. The non-enumerated felony in this case alleged is child abuse. Obviously, the information alleges that the defendant shot and killed the victim, that the victim was under the age of 18. And child abuse must be, according to the third-degree felony murder instruction, defined. I have defined the elements of child abuse in the felony murder instruction.
Oh my God. Just when I thought this case couldn't get any more bizarre, the state is seeking third-degree murder based on child abuse? Is the court going to give this any serious contention or consideration? Because if so, we have a lot of talking to do. Somewhere we wondered why the state would put this vague allegation in the information that Trayvon Martin was 17. No other charge of child abuse, no evidence of anything other than this statement that Trayvon Martin was a minor, 17 years old. First of all, I moved to strike it as surplusage because it's not related to any element of the offense for which George Zimmerman is charged, nor related to any conceivable lesser-included offense. So I guess what's happened now since the time that the state filed its information in April, that they've been lying in wait, collecting all this loosely connected child abuse case law where 2-year-olds have been shot by someone who was reckless with a gun, or some child exposed to horrible deprivation or abuse resulting in death. Just so at this moment, on the day of closing arguments, we would have to deal with it. Well, I can say it's certainly consistent with the way this case has proceeded since April, but it's certainly just as disingenuous as well. This is outrageous. It's outrageous that the state would seek to do this at this time in this case. But it's just hard for me to imagine that the court could take this seriously. Certainly the court wasn't provided with the case law either, nor given any hint that this is where this was going to go.
Well, in all due respect to that statement, the court hasn't been provided a lot of things that have been requested to have hearings that the court has had up until late in the evening, until the last minute, or I requested of it. So that in and of itself is not an argument, and I don't want to go there. So let's go on to the argument about this instruction.
I'm not prepared to make an argument. This was just emailed to me, buried in the set of instructions that the state's obviously been working on for months and months and months, just to spring it on everyone at the last minute.
Their argument today is that the facts support a third-degree felony murder with the underlying enumerated felony being child abuse. That is permissible under the statute.
Judge, this was a trick. Doesn't the court realize this was a trick by the state?
My intention right now is to get through the rest of the jury instructions, because if we have any arguments about the others, I would like to get them resolved. We will come back to this one.